But I guess my question is, isn't that historical default that you're referencing really a default that is rooted in property law and not constitutional law, not in the Second Amendment? I mean, the argument that some have put forward is that this is really a property case, not a Second Amendment case. Yes, it is about guns, but the argument goes, what's really going on here is how states treat a private property owner's consent under circumstances in which everyone agrees that consent is required. You just agreed that consent is required. And so, fine, there are many states, and perhaps even most states, that say we're going to imply that a property owner who opens his property to the public is giving consent for people to carry a gun. Hawaii has said, no, what we're going to do is we're going to say, even if you've opened your property up to the public, you still have to have express consent. We are not going to make our property owners put up signs or be the one that has to affirmatively express. The person who comes on has to have consent, as everybody agreed, and in Hawaii, that consent is expressed. Why isn't that and all the cases that speak to it in the historical record really about the property interests and property rights and not about the Second Amendment?
Because here the law at issue implicates arms-bearing conduct, Your Honor.
But that doesn't mean it implicates. What I'm suggesting is that it might affect, right? And the United States was here just last term talking about how you could have rights and regulations that affect someone's interests, but they actually don't implicate their constitutional rights. And so here I'm saying, yes, gun owners are going to be affected because the property owner says, no, I don't want you to bring your gun on unless you come to me and I give you express consent. But that doesn't mean it implicates their Second Amendment rights for the purpose of Bruin.
Well, in Bruin, the court said that there's a general right to carry. A
general right to carry on public property.
No.
Justice Barrett just explored with you the fact that you don't have a general right to carry on private property.
It's a right to carry in public, Your Honor, not
right.
A right to carry on public property.
But you do agree that there is no right to carry on private property without the owner's consent, right?
Here, the Second Amendment is implicated, especially when anywhere you carry in public. And here, this lawsuit deals with private property that is open to the public.
I understand, but what I'm suggesting is that let's suppose this lawsuit dealt with someone's house and it's not open to the public. Do you concede that there is no Second Amendment right to carry a gun into someone else's house?
I do not, Your Honor.
You do not?
I do not. You'd still be dealing with carry. If someone gives me an invitation, a general invitation to enter into their home, and there's a historical presumption that you're allowed to carry a firearm with you, then if the government passes a law that flips that historical presumption.
Right, but I'm just suggesting that the historical presumption is about the consent, not about your rights. We agreed at the beginning, I thought there was a general consensus that your right to carry is limited to the permission of the owner when you're talking about private property. Like you've already agreed that the Second Amendment right is I would say subordinate, but in the panoply of rights, the right to exclude is superior because the owner can say, no, you can't bring this gun in here. And so once you've done that, these laws that are about licensing or implying that the owner has consented are all in the realm of property law, I think, and not in the realm of the Second Amendment anymore.
I don't see it that way.
You disagree? All right.
Yes, Your Honor.
Thank you.
Counsel.